Okay, now for the dessert. I'm gonna skip the whole letter to American. I just want to dig in. This one is only like 140 pages. You know, that's what time is it? Jesus. Okay, I can get this out. Final report on the Special Counsel's investigations and prosecutions. Volume 1, The Election Case. Report on efforts to interfere with the lawful transfer of power following the 2020 presidential election or the certification of the Electoral College vote held on January 6, 2021. Special Counsel Jack Smith submitted pursuant to 28 CFR subsection 600.8c, Washington, D.C., January 7, 2025. Got the table of contents. Ooh. So this is basically summarizing the indictment. And then this is the actual stuff. But I don't know. Okay, I guess we'll see. Volume 1, The Election Case. On November 18th, 2022, the Attorney General appointed the Special Counsel, Jack Smith, to oversee an ongoing investigation into, quote, whether any person or entity violated the law in connection with efforts to interfere with the lawful transfer of power following the 2020 presidential election or the certification of the Electoral College vote held on or about January 6, 2021, end quote. See Office of the Attorney General, Order Number 5559-2022, appointment of John L. Smith on Special Counsel, November 18, 2022. As a result of the investigation, on August 1st, 2023, a federal grand jury in the District of Columbia charged Donald J. Trump with 4 felony offenses arising from his efforts to unlawfully obtain power by using fraud and deceit to overturn the 2020 election results. After the Supreme Court held last summer that Mr. Trump was immune from prosecution for certain misuse of official power alleged in the indictment, a second grand jury found probable cause to return a superseding indictment charging the same offenses based on his non-immunized conduct. Mr. Trump was thereafter re-elected as President of the United States, and as a result, on November 25th, 2024, the Special Counsel moved to dismiss the case against Mr. Trump because of the Department of Justice's long-standing position that the Constitution forbids that the federal indictment and prosecution of a sitting president. This volume focuses on the election case against Mr. Trump and, consistent with the applicable regulations, provides an explanation of the prosecution decisions reached by the Special Counsel, see 28 CFR subsection 600.8c. The first section of this volume sets forth a summary of key facts gleaned from the investigation, a vast majority of which are already a matter of public record through the litigation that occurred before the District Court. Which, by the way, I went over all of these for so long. It took me so long to write all this down and to make those videos and to post them. Please watch them, because I think I'm going to skip this. I already talked about all this ad nauseum. So if you want to know about the January 6th stuff, there's I think 5 videos on my YouTube explaining the January 6th indictment and going over what actually happened on January 6th and Trump's whole plan laid out step by step to steal the 2020 election. Yes, it happened. Yes, there was so much evidence for it. Yes, conservatives are lying so much when they say otherwise, and they know they are lying. Key point, the Fox Dominion lawsuit. But now I'm getting off track. But I think I'm gonna skip all the January 6th stuff, or the redoing it. So, and go watch my videos on that if you want to know about January 6th. Okay. The second section discusses the statutes that Mr. Trump was charged with violating, applying the facts developed during the investigation to the laws of the Special Counsel's office. The office understood it. I think I'm going to skip that too, because I also go over the laws as well. This section also addresses other charges that the office considered but did not pursue. I might look at that. And the defenses that the office expected Mr. Trump to raise at trial. Oh, that'd be interesting. The third section explains whether the Special Counsel's decision to prosecute Mr. Trump was fully consistent with and indeed was compelled by the principles of federal prosecution. The fourth section describes the office's investigative procedures and policies. Finally, the fifth section of this volume discusses a series of investigative and prosecutive issues that the office confronted in the election case. 1. The results of the investigation. Okay. What's the... Okay, well, we went through all that. Okay, so we'll start at what they thought Trump was going to have his defenses be. Hold on, photo time. Oh, what a day. Look at this peaceful protest. I think that's... Look at how peaceful they're being. Oh my god. Look at them peacefully shoving that flagpole into that violent criminal's left arm. Look at it. Look at the peaceful clashing with the police line. It is so peaceful. Truly the most peaceful protest that we've ever had. Okay, 53. Oh, Jesus. How different are the PDF and... Oh, we're only a couple pages off. Okay, defenses. That's more like it. Before presenting the original indictment to the grand jury, the office considered Mr. Trump's potential defenses to these charges, including a good faith defense, an advice to counsel defense, and constitutional defenses. Joke's on them, they didn't consider the bad faith defense. The office concluded that each of the defenses was legally or factually flawed and thus would not prevail. Hell yeah. First, it was expected that Mr. Trump would argue that he acted in good faith when he sought to stop the transfer of presidential power because he genuinely believed that outcome-determinative fraud had undermined the election's integrity and caused him to lose. Oh my god, finally. This is the one that conservatives use a lot of times, especially in debates. Yeah, but Trump genuinely believed that he lost the election. So, I mean, come on, he wasn't being malicious. He actually thought that the country was being stolen. So, let's see. As set forth above in section 2A, or my videos, the office developed strong proof that Mr. Trump knew that his election fraud claims were false. For example, Mr. Trump made persistent claims of a large number of dead voters in Georgia, including in his speech at the Ellipse on January 6, even though his senior campaign advisor and Georgia Secretary of State, a Republican by the way, I guess now he's a rhino, because he won't bend the knee for Trump, had told him that his claims were untrue. He spread lies, including in his Ellipse speech, of sinister fraudulent, quote, vote dumps in Michigan, even after Michigan's Senate Majority Leader told him that nothing suspicious had occurred. Oh, come on. They'd obviously lie. And Mr. Trump repeatedly made provably false allegations about fraud in Pennsylvania, despite having been told by the chairman of the state Republican Party that the vote count was occurring as expected. What do you mean? Just another rhino? Even if Mr. Trump maintained that he sincerely believed he won the election, a conclusion unsupported by the evidence collected in the investigation. By the way, there's also just so many more statements, like statements from Barr, statements from Pence, statements from his campaign advisors, his lawyers, statements from Trump himself about not believing his lawyers' claims, Republican governors, other Republican members of state branches. There's all laid down in the indictments, which I cover in my videos. I'm telling you, please watch the videos so that you can know more, because why not? Why not know about January 6th? Why not know about it? He's going to be our president, might as well know what he's done. There we go. Okay. It would not provide a defense to the Section 371 charge. A defendant may not use deceit to obstruct a government function, even if he believes the function itself to be unconstitutional, because, quote, a claim of unconstitutionality would not be heard to excuse a voluntary, deliberate, and calculated course of fraud and deceit, end quote. Dennis 384, U.S. at 867. Quote, one who elects such a course as a means of self-help may not escape the consequences by urging that his conduct be excused because the statute which he sought to evade is unconstitutional, end quote. There are, quote, appropriate and inappropriate ways to challenge, end quote, perceived illegalities. Just as the president of a company may be guilty of fraud for using knowingly false statements of fact to defraud investors, even if he subjectively believes that his company will eventually succeed, see e.g. United States v. Arif, United States v. Chavez, Mr. Trump could be convicted of using deceit to obstruct the government function by which the results of the presidential election are collected, counted, and certified, even if he established that he subjectively believed that he had reason to do so because of his claims that the election was, quote, rigged. So, I mean, basically saying, hey, just because you might think this doesn't mean that you are allowed to do any of this. A simpler metaphor would be like, just because you think that the bank owes you money doesn't mean that you can go in and rob the bank and not expect charges. You still rob the bank. No matter how much you believe that they owed you money, you can't just rob a bank. Even if they do owe you money, you can't just rob a bank. There are means to go through this. And in the case of the election, legal means. It bears emphasis that Mr. Trump's knowing deceit was persuasive throughout the charged conspiracies. This was not a case in which Mr. Trump merely misstated a fact or two in a handful of isolated instances. What? You don't say. On a repeated basis, he and co-conspirators used specific and knowingly false claims of election fraud in his calls and meetings with state officials in an effort to induce them to overturn the results of the election at those states. To his own vice president, to induce Mr. Pence to violate his duty during the congressional certification proceeding, and on January 6, as a call to action to the angry crowd that he had gathered at the ellipse and sent to the Capitol to disrupt the certification proceeding. Mr. Trump and co-conspirators used other forms of deceit as well, when they falsely represented that the fraudulent electoral votes would be used only if Mr. Trump prevailed in pending contests in those states, and when they caused the fraudulent electors to falsely swear that they were duly certified and send those false certifications to Congress. Regardless of any claim that Mr. Trump subjectively believed the outcome of the election was unfair or rigged, the office concluded that these knowingly deceitful statements and acts would overcome any good faith defense. The office also charged that Mr. Trump might claim that his consultation with attorneys, several of whom were co-conspirators, should negate a finding that he acted with a criminal state of mind. In pretrial litigation, the court granted the government's motion that Mr. Trump should be required to declare whether he intended to employ such a defense and, if he did, to produce the discovery required by the attendant waiver of Mr. Trump's attorney-client privilege. UCF number 147. A defense claimed that he relied in good faith on his attorney's advice is, quote, not an affirmative defense that defeats liability even if the jury accepts the government's allegations as true, end quote, but functions insisted as, quote, evidence that, if believed, can raise a reasonable doubt in the minds of the jurors about whether the government has proved the required element of the defense that the defendant has an unlawful intent, end quote. United States v. Scotty. Under D.C. Circuit law, an advice of counsel defense consists of two elements. The defendant, 1, relied in good faith on the counsel's advice that his course of conduct was legal, and 2, made full disclosure of all material facts to his attorney before receiving the advice at issue. United States v. Gray Burris. The office concluded that Mr. Trump chose to raise such a defense. It would fail, because an advice of counsel defense is not available. Quote, where counsel acts as an accomplice in the crime, end quote. United States v. West. The evidence showed that the central attorneys on whom Mr. Trump may have relied for such a defense, such as co-conspirator 1 or 2, were, quote, partners in a venture, end quote, with the result that any advice of counsel defense necessarily would fail. Citing United States v. Carr. A criminal lawyer has no license to act as a lawyer criminal. Based. Co-conspirator 1 assisted Mr. Trump in using knowingly false claims of election fraud in furtherance of his charged conspiracies. At press conferences, at hearings before legislators in the targeted states, and directly with officials in the targeted states, co-conspirator 1 made a wide range of specific, though ever-changing, false claims of election fraud. Oh yeah. Co-conspirator 1 continued to do so after his lies were publicly or directly debunked. Co-conspirator one's involvement spanned from his insistence that Mr. Trump declare victory on election night to the voicemails that co-conspirator one left for senators on the night of January 6, using false claims of election fraud to ask that the legislators further delay the certification. So, if you can't tell, co-conspirator one is Rudy Giuliani, and yes, that is true. After January 6, after all the violence and the death that occurred, Giuliani was calling up senators, still asking them, hey, can you still, delay the proceeding? Come on, give us a couple more days, Just a few more days. Oh my god, it's so fucking irritating. And none of this will get... Well, I guess Giuliani's getting his comeuppance because he's going fucking bankrupt for his lies about the State Farm Arena video. So, I guess I can find solace in that. Co-conspirator 2 was instrumental in Mr. Trump's efforts to organize his electors to cast fraudulent votes and send them to the vice president, and then to pressure the vice president to use the fraudulent electoral certificates to overturn the election results. Through his involvement in Mr. Trump's conspiracies, co-conspirator 2 conceded privately to other attorneys, both private attorneys and those responsible for advising Mr. Trump and the vice president, that his plans violated federal law and would not withstand scrutiny in court. This is referring to John Eastman, who was co-conspirator 2. Who, yes, he did say that, for example, if his whole theory about the ECA, the Electoral Count Act, which basically set up a whole current system of the Electoral College, he admitted that his theory that the vice president could overturn or undo the results of the election, rejecting ballots, he admitted that it would lose 9-0 in the Supreme Court. 9-0, and you're talking about a court with people like Clarence Thomas and Alito on it. 9-0 still. So, and yeah, he still pushed it. What a lying piece of shit. Furthermore, Mr. Trump could not have succeeded in showing that he relied in good faith on legal advice from these attorneys. The evidence showed that Mr. Trump was not looking to co-conspirator 1 or 2 for legal advice. Instead, Mr. Trump was the head of a conspiracy who sought legal cover from his co-conspirators. Yeah, true. As co-conspirator 1 acted repeatedly in furtherance of the conspiracies, multiple advisors to Mr. Trump warned him that co-conspirator 1 would not successfully challenge the election results and was not acting in Mr. Trump's best interest. Mr. Trump ignored them all because he was now relying on co-conspirator 1 as an attorney. Don't say that Giuliani for being a shit lawyer. Based. Similarly, co-conspirator 2's willingness to advocate for actions that he knew and even privately concealed were unlawful demonstrates that both he and Mr. Trump understood his role was not that of an attorney offering legal advice on which Mr. Trump was acting. For instance, in a lawsuit in Georgia, co-conspirator 2 filed a false certification by Mr. Trump after having read to other attorneys in an email that both he and Mr. Trump knew some of the allegations incorporated in the filing were inaccurate. Oh yeah, so fucking dumb. And co-conspirator 2's decision to advocate to the Vice President's Counsel and Chief of Staff on January 5th, 2021, the Vice President should unlawfully reject legitimate electoral certificates, an act that co-conspirator 2 had previously recognized was not supported by the Constitution or federal law, was a sharp reversal from his position just one day earlier and happened only because Mr. Trump had made clear that it was his preferred strategy. The office was otherwise confident that it would be able to demonstrate that with respect to all attorneys, Mr. Trump cannot meet the elements of the defense, such as the requirement that he makes full disclosure to any attorneys of all relevant facts and then rely faithfully on their advice. See Gray Bureaus. Finally, the office anticipated that Mr. Trump would claim that his conduct was protected by the First Amendment. It's kind of a cringe one. I kind of already went over the First Amendment stuff. So, I guess, watch my videos. Other charges, okay. I think this is a very, important stuff, Conservatives say that they went at him, and Trump says, no one's went at him, no one's went at anybody like they have him, so let's see, Did they really go after him as hard as they could have? The office considered, but ultimately opted against, bringing other charges. One potential charge was 18 U.S.C. subsection 2383, sometimes referred to as the Insurrection Act, which provides that, quote, whoever incites, sits on foot, assists, or engages in any rebellion or insurrection against the authority of the United States or the laws thereof, or gives aid or comfort thereto, shall be fined under this title, or imprisoned not more than 10 years, or both, and shall be incapable of holding any office under the United States, end quote. 18 U.S.C. subsection 2383. Section 2383 originated during the Civil War as part of the Second Confiscation Act of 1862. See Act of July cases interpreting Section 2383 are scarce and arose in contexts that provide little guidance regarding its potential application in this case. See United States v. Greathouse. Construing the original version of the act to encompass treason, consisting of arming a vessel to commit hostilities against United States vessels in the context of the rebellion by the Confederate States. United States v. Cathcart, rejecting legal argument that treason against the United States was legally impossible in the context of the rebellion by the Confederate States. Grand jury charge describing offense in the context of a labor dispute involving interference with transportation of the mail. Grand jury charge that insurrection is arising against civil or political authority and requires such a number of persons as would constitute a general uprising in that particular locality, in the context of offense or obstructing the mails. It does not appear that any defendant has been charged with violating the statute in more than 100 years. To establish a violation of Section 2383, the office would first have to prove that the violence at the Capitol on January 6, 2021 constituted an, quote, insurrection against the authority of the United States or the laws thereof, and then that Mr. Trump incited or assisted the insurrection or gave aid or comfort thereto, end quote. 18 U.S.C. subsection 2383. Courts have found or described the attack on the Capitol as an insurrection. In Anderson v. Griswold, the Colorado Supreme Court found that Mr. Trump engaged in an insurrection, as that term is used in Section 3 of the 14th Amendment. Federal courts in the District of Columbia have also used the term insurrection to describe the attack on the Capitol, but did so in cases where there was no criminal charge under Section 2383. See United States v. Stuk. As this court and other courts in the United States District Court for the District of Columbia have stated previously, what occurred on January 6 was in fact an insurrection and involved insurrectionists, and therefore the terms to which defense object are accurate descriptors. United States v. Carpenter, what occurred on January 6 was in fact a riot and an insurrection, and it did in fact involve a mob. See also United States v. Munchell. Using the term insurrection is a case that did not involve Section 2383. These cases, however, did not require the courts to resolve the issue of how to define insurrection for purposes of Section 2383, or apply the definition to the conduct of a criminal defendant in the context of January 6. The office recognized why courts described the attack on the Capitol as an insurrection, but it was also aware of the litigation risk that would be presented by employing this long-dormant statute. As to the first element under Section 2383, proving an insurrection against the authority of the United States or the laws thereof, the case the office review provided no guidance on what proof would be required to establish an insurrection, or to distinguish an insurrection from a riot. Generally speaking, an, quote, insurrection is arising against civil or political authority, the open and active opposition of a number of persons to the execution of a law in a city or a state, end quote. See also insurrection Merriam-Webster, an act or instance of revolting against civil authority or an established government. Insurrection American Heritage Dictionary, the act or an instance of open revolt against civil authority or constituted government. The Oxford English Dictionary, the action of rising in arms or open resistance against established authority or governmental restraint. Some sources distinguish an insurrection from a riot or offense connected with mob violence by the fact that an insurrection there is an organized and armed uprising against authority or operations of government, while crimes going out of mob violence, however serious they may be, and however numerous the participants, are simply unlawful acts and disturbance of the peace which do not threaten the stability of the government or the existence of political society. I would agree with this. Insurrection is specifically against governmental authority. And, I mean, J6 was that. Black's Law Dictionary. Noting Mr. Trump's argument that an insurrection is more than a riot but less than a rebellion, and agreeing that an insurrection falls along a spectrum of related conduct. In case law interpreting insurrection in another context, one court has observed that an insurrection typically involves overthrowing a sitting government rather than maintaining power, which could pose another challenge to proving beyond a reasonable doubt that Mr. Trump's conduct on January 6 qualified as an insurrection, given that he was the sitting president at the time. That is true. That would make it difficult. And that is a common argument that conservatives make. Oh, he was overthrowing himself. Like, no, you dumb fuck. In every case, over the course of over 60 years, to find the existence of an insurrection within the meaning of an insurance policy, the insurrection has occurred against, not by, the established, effective, and de facto government. Pan Am World Airways Inc. versus Aetna Cos and Co. The district court held that the word insurrection means 1. A violent uprising by a group or movement, 2. Acting for the specific purpose of overthrowing the constituted government and seizing its powers. Home Ends Co. of New York versus Davila, noting that Puerto Rico extremists had a maximum objective to overthrow of the insular government on the island. That group's uprising would constitute insurrection. Hartford Fire Ends Co. versus W. Union. A Russian-backed separatist group's attack on a plane in service of overthrowing the current government in eastern Ukraine was an insurrectionary act. U.S. Rose & Co. Inc. versus CIGNA Worldwide Insular Co. Applying Davila and finding that while individuals outside the Liberian government led their respective armies in a violent uprising against the Liberian government, damage to properties fell within an insurance contract's insurrection clause. The office did not find any case in which a criminal defendant was charged with insurrection for acting within the government to maintain power, as opposed to overthrowing it or thwarting it from the outside. Applying Section 2383 in this way would have been a first, which further weighed against charging it, given the other available charges, even if there were reasonable arguments that might apply. As to the second element under Section 2383, there does not appear to have been a prosecution under the statute for inciting, assisting, or giving aid or comfort to rebellion or insurrection. The few relevant cases that exist appear to be based on the defendant directly engaging in rebellion or insurrection, but the officer's proof did not include evidence that Mr. Trump directly engaged in insurrection himself. Thus, however, strong the proof that he incited or gave aid and comfort to those who attacked the Capitol, application of those theories of liability would also have been a first. See Alexander Cesis. The likelihood of conviction under the federal incitement to insurrection statute. 18 U.S.C. subsection 2383 is fraught with uncertainty because no federal court has interpreted it, which is a shame. The office determined that there were reasonable arguments to be made that Mr. Trump's ellipse speech incited the violence at the Capitol on January 6 and could satisfy the Supreme Court standard for incitement under Brandenburg v. Ohio, holding that the First Amendment does not protect advocacy, quote, directing to inciting or producing imminent lawless action and likely to incite or produce such action, end quote. Particularly when the speech is viewed in the context of Mr. Trump's lengthy and deceitful voter fraud narrative that came before it. For example, the evidence established that the violence was foreseeable to Mr. Trump, that he caused it, that it was beneficial to his plan to interfere with the certification, and that when it occurred, he made a conscious choice not to stop it and instead to leverage it for more delay. But the office did not develop direct evidence, such as an explicit admission or communication with co-conspirators, of Mr. Trump's subjective intent to cause the full scope of the violence that occurred on January 6. Therefore, in light of the other powerful charges available, and because the office recognized that the Brandenburg standard is a rigorous one, see NAACP versus Claiborne Hardware Co., speech delivered in passionate atmosphere that referenced possibility that necks would be broken and violators of boycott would be disciplined did not satisfy Brandenburg standard. Brandenburg. A reversing conviction where KKK leader threatened vengeance for suppression of the white race. It concluded that pursuing an incitement to insurrection charge was unnecessary. By comparison, the statutes that the office did charge have been interpreted and analyzed in various contexts over many years. The office had a solid basis for using sections 371, 1512, and 241 to address the conduct presented in this case, and it concluded that introducing relatively untested legal theories surrounding Section 2383 would create unwarranted litigation risk. Importantly, the charges that office brought fully addressed Mr. Trump's criminal conduct, and pursuing a charge under Section 2383 would not have added to or otherwise strengthened the office's evidentiary presentation at trial. For all these reasons, the office elected not to pursue charges under Section 2383. So that was basically talking about, hey, we could have used the Insurrection Act, we could have charged him with this, but because of the lack of rulings as related to the definition of insurrection, which we would have had to prove, and incitement of insurrection, given the confident aid, it would be unnecessary, especially considering that, hey, we got all these other charges anyways that we can use and will give us more than enough reprieve for the actions that Trump caused. So there's no point on undergoing the extensive strain and research and defense of these charges when they can just use these ones and get as much as they want anyways. So, yeah. Okay. Co-conspirator liability. As described in the factual recitation above, Mr. Trump was charged with participating in crimes with at least 6 co-conspirators, and the office's investigation uncovered evidence that some individuals shared criminal culpability with Mr. Trump. Before the department concluded that this case must be dismissed, the office had made a preliminary determination that the admissible evidence could justify seeking charges against certain co-conspirators. This report should not be read to allege that any particular person other than Mr. Trump committed a crime, nor should it be read to exonerate any particular person. Oh, well. Okay. The principles of federal prosecution. Okay. As set forth above, the office concluded that Mr. Trump's conduct violated several federal criminal statutes and that the admissible evidence would be sufficient to obtain and sustain a conviction. Therefore, under the long-standing principles of federal prosecution, the office considered whether 1. The prosecution would serve a substantial federal interest, 2. Mr. Trump was subject to effective prosecution in another jurisdiction, or 3. There existed an adequate non-criminal alternative to prosecution. U.S. Department of Justice Manual, subsection 9-27.220. As described below, multiple substantial federal interests were served by Mr. Trump's prosecution. He was not subject to effective prosecution in another jurisdiction, and there was no adequate non-criminal alternative to prosecution. The Supreme Court's decision on presidential immunity, handed down at the initial decision to prosecute and analyzed below in section VD2, did not alter the office's view that the principles of federal prosecution compelled prosecuting Mr. Trump. Although that decision prevented use of certain evidence uncovered regarding Mr. Trump's misuse of presidential power, he also engaged in non-immune criminal conduct that is set forth in the superseding indictment, which I went over. Accordingly, this section discusses only evidence that was not immunized, either because it involved Mr. Trump's private conduct or because the office would have rebutted any presumption of immunity. Prosecuting Mr. Trump served multiple substantial federal interests. Mr. Trump's prosecution served multiple federal interests, including the federal interest in the integrity of the United States process for collecting, counting, and certifying presidential elections, and in a peaceful and orderly transition of presidential power. The federal interest is ensuring that every citizen's vote is counted. A federal interest in. The federal interest in protecting public officials and government workers from violence, and the federal interest in fair and even-handed enforcement of the law. All of these federal interests, which are rooted in the law, the Constitution, and our basic democratic values, are substantial and command protection from Mr. Trump's criminal design to subvert them. feel like that's pretty obvious. Yeah, I feel like this is pretty obvious. Like, the government has an interest in protecting the elections, ensuring that all the votes are counted, and making sure that no one's getting threatened. That's pretty obvious. I'm looking for, like, some new stuff, New stuff. Give me the icky stuff about all the messed up hurdles that you had to go through. Trump is not subject to effective prosecution in other jurisdictions. Makes sense, since he's doing federal stuff. There was no adequate non-criminal alternative to prosecution. Makes sense. Mr. Trump's conduct has no historical analog. Okay. Yeah, that's a big claim. Oh, Trump's conduct, people have done it before, I think the Hawaii stuff with JFK, 2001 is brought up a lot, Grant, that kind of stuff. Yep, all down here. Okay. The historical episodes that Mr. Trump invoked, arising from elections in 1800, 1824, 1876, 1960, 2000, 2004, and 2016, did not involve similar conduct and did not supply a valid reason to decline to bring charges here. In the litigation, the office addressed each historical episode he cited, and explained why none was meaningfully similar to the charged conduct. Taken together, those episodes showed that, quote, there have been times, as in 1800, 1876, and 1960, when genuine questions have arisen over which slate of electors from a particular state has been duly appointed, end quote. Quote, there has also been times, as in 1824, when the failure of any candidate to obtain a majority of electoral votes has thrown the election to the House of Representatives, end quote, end quote. There has been times, as in 2004 and 16, when those dissatisfied with the results have sought to raise objections to the electoral vote count, resulting in either the objections being overruled or, in one case, a brief adjournment designed as an Ohio-focused protest vote without the hope or even the hint of overturning the victory of the president, end quote. But none of the historical episodes at issue involved, quote, any attempt by any person to use fraud and deceit to obstruct or defeat the government function that would result in the certification of the lawful winner of a presidential election, end quote. The district court found that there were no historical analogs to Mr. Trump's alleged criminal conduct. When Mr. Trump filed a motion to dismiss the indictment on a claim that he was being selectively prosecuted because of a historical, quote, track record of similar unprosecuted efforts, end quote, to challenge elections, the district court rejected it, explaining that Mr. Trump was, quote, not being prosecuted for publicly contesting the results of the election. He's being prosecuted for knowingly making false statements in furtherance of a criminal conspiracy and for obstruction of election certification proceedings, end quote. Likewise, in its opinion denying Mr. Trump's immunity motion, the district court found that, quote, none of the contested elections, end quote, Mr. Trump, quote, invokes is analogous to this case, end quote, as none involved, quote, any allegation that any official engaged in criminal conduct to obstruct the electoral process, end quote. Jeez, so many freaking words. Investigative procedure and policy. Upon appointing the special counsel, the Attorney General explained that the appointment, quote, underscores the department's commitment to both independence and accountability in particularly sensitive matters. It also allows prosecutors and agents to continue their work expeditiously and to make decisions indisputably guided only by the facts and the law, end quote. The Attorney General also noted that, quote, although the special counsel would not be subject to the day-to-day supervision of any official of the department, he must comply with regulations, procedures, and policies of the department, end quote. The office conducted its work accordingly. The investigative process. Employing traditional investigative tools, including voluntary interviews, grand jury subpoenas, and search warrants, and subject to the same legal requirement binding on all federal prosecutors, the office, spanning the period predating the special counsel's appointment to the completion of its work, developed a thorough record of independently verified facts on which it based its prosecutive decisions in the election case. The investigative record comprised voluntary witness interviews and grand jury testimony from numerous individuals, as well as voluminous records such as emails, text messages, encrypted messages, memoranda, and other documents. These records were obtained through both voluntary productions by dozens of witnesses and through compulsory process and court orders, including grand jury subpoenas directed to witnesses and entities, court orders for non-content information such as sender, recipient, date, and time from electronic communications accounts, and search warrants to obtain evidence from physical sources and/or locations, electronic devices, and email and iCloud accounts. The office has obtained records from other components of the DOJ, including the U.S. Attorney's Office for the District of Columbia, and other federal agencies, including the National Archives, Department of Homeland Security, Department of Defense, and Office of the Director of National Intelligence. Further, the office collected more than 1 terabyte of data from publicly available sources such as social media postings and websites. All discoverable material was provided or made available to Mr. Trump and Discovery during the prosecution of the election case. 1 terabyte. And that's just of the data from the publicly available stuff. Jeez. You can't say that they didn't work hard. Throughout its work, the office complied with, quote, the rules, regulations, procedures, practices, and policies of the DOJ, end quote, including consulting the Justice Manual, the department's publicly available guidebook on policies and procedures, and consulting or obtaining requisite approvals from other department components. Publicly available guidebook on policies and procedures. Maybe conservatives should maybe look this up if they disagree and think that some policies and procedures are being broken. Maybe read. I know it's a tough thing to do. For example, as required under the Justice Manual, the office obtained approvals from the Criminal Division's Office of Enforcement Operations, which provides legal guidance on the use of sensitive law enforcement tools, such as subpoenas and search warrants involving attorneys. And as discussed more below, the office consulted the Criminal Division's Public Integrity Section, PIN. Oh, that's a cute name. Which oversees the investigation and prosecution of federal crimes affecting government integrity, pursuant to Justice Manual requirements pertaining to the service of subpoenas and other process on members of Congress, the use of election fraud charges, and the department's election year sensitivities policy, a long-standing department policy regarding the conduct of sensitive investigations during an election year. Wow. Who would know? They have a policy specifically around stuff involving election years, around the time of the election year. Wow, you mean that they took into account that it was an election year? You mean that they thought the people that went to school for like a decade and have been working for decades actually thought, hey, how will this affect the election? Should we take into consideration stuff like that? No, only retarded conservative, I should mention, 1799 could only think of such a thing as like, are they even thinking of how this will impact the election? This is election interference. Only such smart people could come up with such impeccable thoughts going through those small, insignificant minds. Wow, it's insane. Even when not required in accordance with the best traditions of the department, the office actively sought advice and guidance from subject matter experts throughout the department. For example, the office requested assistance from the Civil Division and Office of Information Policy (OIP) on civil litigation for public access to investigative and prosecutive materials, and the office conferred with the Office of the Solicitor General (OSG), which is responsible for supervising and conducting government litigation at the United States Supreme Court, the Office of Legal Counsel (OLC), which provides binding legal advice to the executive branch, and the Criminal Division's Appellate Section, which conducts and oversees the Department's criminal appellate litigation on complex statutory, constitutional, and other legal issues, including regarding charging decisions in the original and superseding indictments, or SUPRA, or C-SUPRA. At Section 2, Mr. Trump challenged the District Court's order on extrajudicial statements, C-Infra. At Section VB, Mr. Trump's executive privilege claims, C-Infra. At Section VC, and Mr. Trump's immunity's challenge to the indictment, C-Infra. At Section VD. Investigative and prosecutive procedures in an election year. Wow. Mr. Trump's announcement of his candidacy for president while 2 federal criminal investigations were ongoing presented an unprecedented challenge for the Department of Justice and the courts. Given the timing and circumstances of the special counsel's appointment and the office's work, it was unavoidable that the regular process of the criminal law and the judicial system would run parallel to the election campaign. Mr. Trump's position was that when the judicial process conflicted with his election campaign, the courts should always yield. As discussed below, the courts did not agree. Based. Under these unique circumstances, the department's actions would be criticized by one constituency or another, regardless of which path the investigations took. True. Accordingly, the office leaned on established department policy, practice, and wisdom, and focused on doing its job promptly and thoroughly, as they should. From the outset and throughout its work, the office recognized the weighty issues presented by the matters under its mandate and operated on the principle that the best interests of the department and the nation required prompt investigation and decision-making. The office's exceptional working pace ensured that its investigative work could be completed, charging decisions could be made, and any necessary indictments could be returned by the summer of 2023, long before the election. The office had no interest in affecting the presidential election, and it complied fully with the letter and spirit of the department's policy regarding election year sensitivities. It did so through fundamentally sound practices, moving its investigations swiftly, making charges decisions, and returning indictments well before the election, litigating its cases on the timetable set by the courts, and consulting with PIN. Penn. Such a cute name. The department's election year sensitivities policy. The staff of the office was deeply familiar with and committed to the department's election year sensitivities policy, as it included fraud and public corruption prosecutors with many years of experience working in and leading PIN. The special counsel himself and one of his counselors had served as chief of PIN. 2 of the attorneys had been deputy chiefs in PIN, and 2 other attorneys in the office had been trial attorneys in PIN. Collectively, prosecutors in the office had many years of experience providing training, advice, and guidance to prosecutors and law enforcement agents throughout the department on how to comply with the department's election-related policies. In fact, the counselor in the office who had previously served as chief of PIN was one of the drafters of the first election year sensitivities memorandum issued to department attorneys. Wow! You mean that these guys know those stuff? That's crazy! The department's policy regarding elections has 2 overlapping components. The first is focused on the prosecutor's purpose. It prohibits prosecutors from taking any action or timing any action for the purpose of affecting an election. Justice Manual. That flat prohibition applies to all actions by prosecutors and at all times during an investigation or prosecution. The section and overlapping component focuses on safeguarding the department's reputation for fairness and nonpartisanship, requiring the prosecutors to take particular care in an election year and consult with PIN when an action is, quote, likely to raise an issue or the perception of an issue, end quote. Jeez. These policies are well established within the department. In 2008, in the wake of allegations and investigations concerning politicization in the department, and recognizing that there was uncertainty regarding the terms of the department's policies and practices in election years, the Criminal Division and PIN evaluated the feasibility of establishing a specific and definitive set of rules regarding the duty to avoid interference with elections in the run-up to an election. While prosecutors had long been advised to exercise particular care in politically sensitive areas and the 2 or 3 months immediately prior to an election, the department had never had a formal 60-day or 90-day rule that governed such situations. As part of its evaluation in 2008, the department considered whether to codify a particular rule, but ultimately concluded that the best course was, instead, to provide guidance in the form of an Attorney General memorandum addressing the need for particular care to protect the department's reputation for impartiality in an election year, and setting forth in writing the core principle that prosecutors and agents may not act for a political purpose. On March 5, 2008, Attorney General Michael Mukasey issued the first election year sensitivities memorandum setting forth this guidance. In a relevant part, the Attorney General memorandum said, Department of Justice employees are entrusted with the authority to enforce the laws of the United States and with the responsibility to do so in a neutral and impartial manner. This is particularly important in an election year. Now that the election season is upon us, I want to remind you of the Department's existing policies with respect to political activities. The Department of Justice has a strong interest in the prosecution of election fraud and other election-related crimes, such as those involving federal and state campaign finance laws, federal patronage laws, and corruption of the election process. As department employees, however, we must be particularly sensitive to safeguarding the department's reputation for fairness, neutrality, and nonpartisanship. Simply put, politics must play no role in the decisions of federal investigators or prosecutors regarding any investigations or criminal charges. Law enforcement officers and prosecutors may never select the timing of investigative steps or criminal charges for the purpose of affecting any election or for the purposes of giving advantage or disadvantage to any candidate or political party. Such a purpose is inconsistent with the department's mission and with the principles of federal prosecution. If you are faced with a question regarding the timing of charges or of investigative steps near the time of a primary or general election, please contact the Public Integrity Section of the Criminal Division for further guidance. Since 2008, Attorney General have issued memoranda containing substantially the same guidance to prosecutors and agents in each election year. In August 2022, just 3 months before the Attorney General appointed the special counsel, the department codified its election year policies and the Justice Manual. Federal prosecutors and agents may never select the timing of any action, including investigative steps, criminal charges, or statements, for the purpose of affecting any election or for the purpose of giving an advantage or disadvantage to any candidate or political party. Such a purpose is inconsistent with the department's mission and with the principles of federal prosecution. See subsection 9-27.260. Any action likely to raise an issue or the perception of an issue under this provision requires consultation with the Public Integrity Section, and such actions shall not be taken if the Public Integrity Section advises that further consultation is required with the Deputy Attorney General or Attorney General. Implementation of the election year sensitivities policy can raise challenging questions. Taking action may be viewed as helping a candidate, while refraining from action may be viewed as helping that candidate. Catch 22. This challenging landscape counsels in favor of structuring and timing investigations in a manner that enables prosecutors and agents to avoid these issues as much as possible and do what they do best, focus on the needs of the case. Consistent with that, Penn often counsels prosecutors to move their investigations along promptly and avoid unnecessary delay that can needlessly place them in the position of deciding whether to take overt action or bring charges in the period immediately before an election. Because of the office's deep familiarity and experience with these policies, it focused on completing both of its investigations promptly and making timely charging decisions long before this election. Pre-indictment procedures. During the investigation and prosecution of this case, the office consulted regularly with Penn. For example, because the election case involved election fraud charges under 18 U.S.C. subsections 241 and 371, the office consulted with Penn and its election crimes branch prior to returning the election case indictment in the District of Columbia. As required by Justice Manual subsection 9-85.210, violations of campaign financing laws, federal patronage laws, and corruption of elections, consultation requirement. In addition, the office consulted with Penn regarding investigative steps that involved gathering evidence connected to congressional staff pursuant to Justice Manual subsection 9-85.110, investigations involving members of Congress. As discussed below in section VA2, the office also consulted Penn regarding issues that arose in litigation involving the speech or debate clause, U.S. Constitution Article 1, subsection, section 6, clause 1. I think that's just section. No subsection. A unique constitutional protection that provides a form of immunity to legislative acts by members of Congress and their staff. However, because the office proceeded expeditiously with its investigations and charging decisions, no election year sensitivities consultation with Penn was required prior to returning the original indictment in either the classified documents case in June of 2023 or the election case in August of 2023. Post-indictment procedures. The two components of the department's election year sensitivities policy play out differently in the context of post-indictment litigation. First, the bedrock principle that prosecutors may not take any action for the purpose of effecting an election or providing an advantage or disadvantage in any candidate or party applies fully during post-indictment litigation. On this score, the office did not take a single action at any time for any such purpose. Rather, the office's mission was at all times to uphold the law and carefully follow the requirements of the criminal justice process. Wow. The office investigated itself, and they determined the office did everything right. Actually, based on. Unlike the purpose-focused component of department policy, the component that focuses on the department's reputation for impartiality stands on a different footing with respect to pre-indictment and post-indictment activity. This component of the policy applies fully to the timing of actions by prosecutors prior to indictment, bringing charges, taking over investigative steps, and making public statements. Justice Manual, subsection 9-85.500. For such actions, prosecutors must take election year sensitivities into account, and they are required to consult with Penn. However, once the case is charged, this component of the policy does not limit the ability to litigate according to the schedule set down by the court and does not require consultation with Penn for such litigation. Whether it is during an election year or any other time, the duty of prosecutors often after indictment is to litigate their cases fully and zealously, consistent with the Constitution, United States Code, Federal Rules of Criminal Procedure, Rules of Professional Responsibility, and dictates of the calendar set forth by the court. The prosecutor has urged speedy trials, with which I agree, and it's now in the hands of the judicial system, not in our hands. Once a case is charged, no policy of the department limits the ability of prosecutors to litigate effectively on the schedule set by the court, and that is what the office did. Consistent with the department's policy, after indictment, the office litigated the election case according to the schedule set down by the District Court, the D.C. Circuit, and the Supreme Court. Given the gravity of the issues presented by the charges, the office sought to move the case forward expeditiously for two central reasons unrelated to the election. First, the Speedy Trial Act mandates expeditious resolution of criminal cases, and it does so not only for the benefit of the accused, but in the best interest of the public. See Zedner v. United States. Quote, the Speedy Trial Act was designed with the public interest firmly in mind. End quote. Strunk v. United States. The public interest is a broad sense, as well as the constitutional guarantee. The public interest in a broad sense, as well as the constitutional guarantee, commands prompt disposition of criminal charges. Cobbledick v. United States. Encouragement of delay is fatal to the vindication of the criminal law. Second, those fundamental interests were heightened in this case, which raised matters of utmost gravity, urgency, and national concern, charging the former president with conspiring to thwart the peaceful transfer of power through lies that undermined the democratic process and ultimately fueled a violent attack on the U.S. Capitol. These criminal charges warranted prompt and fair disposition, and that is what the office sought to achieve. Both during the investigation and after the case were charged, however, Mr. Trump sought to delay the proceedings, taking the position that when the judicial process conflicted with his election campaign, the court should always yield. See proposing April 26, 2026 trial date, emphasizing that, quote, no major party presidential candidate has ever been charged while in the middle of a campaign. Mr. Trump's counsel arguing, the easiest solution to all of this is an obvious one, and that is to adjourn the case after the presidential election. That's the solution. Asking court to reconsider scheduling order, emphasizing that President Trump is the leading candidate in the presidential election, which is just weeks away. The courts did not agree. Based. They consistently rejected Mr. Trump's efforts to delay or stop the proceedings. The court's words and actions throughout the litigation reflected their fundamental commitment to the operation of the judicial process, notwithstanding the election campaign. The public has a right to a prompt and efficient resolution of this matter. The fact that the defendant is engaged in a political campaign is not going to allow him any greater or lesser latitude than any defendant in a criminal case. And so what the defendant is currently doing, the fact that he's running a political campaign currently has to yield to the orderly administration of justice. I cannot, and I will not, factor into my decision the effect it's going to have on a political campaign for either side. United States v. Trump, delaying the trial date until after the election, as Mr. Trump proposes, would be counterproductive, create perverse incentives, and irresolutely burden the judicial process. But there was another fundamental constitutional interest at stake here. The existence of a political campaign or political speech does not alter the court's historical commitment or obligation to ensure the fair administration of justice in criminal cases. A trial participant's engagement in political speech cannot degrade or diminish that central judicial function. Expediting briefing and oral argument. Accelerating the schedule for Mr. Trump to seek any further review. The office also sought to move the election case forward expeditiously in the Supreme Court based upon the public interest in a prompt resolution of the case and the precedent set by the Watergate special prosecutor in United States v. Nixon, where the court, quote, granted both the United States petition for certiorari before judgment and also the President's cross petition for certiorari before judgment because of the public importance of the issues presented and need for their prompt resolution, end quote. The office filed a petition for certiorari before judgment, which would have moved the election case directly to the Supreme Court from the District Court, and argued that the court should follow the Nixon model. The Supreme Court did not grant the office's petition for certiorari before judgment. However, like the D.C. Circuit, the Supreme Court ultimately expedited its consideration of the case, further confirming the office's emphasis on the strong public interest in a prompt resolution. Following the Supreme Court's immunity decision, the office again proceeded in a manner that was fully consistent with the letter and spirit of the department's election year sensitivities policy, litigating the case according to the schedule established by the District Court, taking action based upon the law and the best interests of the case, and consulting with Penn. Upon receiving the decision, the office immediately began a multifaceted process to determine the best way forward, including 1. A thorough evaluation of the opinion itself, 2. An exhaustive and detailed review of the evidence and the allegations in the original indictment to determine whether there was sufficient non-immune evidence to support the charges in light of the opinion. 3. Once the office determined that there was sufficient non-immunized evidence, an evaluation of whether to litigate the case based on the existing grand jury record and indictment, or instead seek a superseding indictment that would be presented to the grand jury that had not heard any immunized evidence. And 4. Given the timing, evaluate whether all the necessary steps could be undertaken consistent with the election year sensitivities policy. The office determined that there was sufficient non-immunized evidence to support the charges and that the best course of action for the case was to obtain a superseding indictment that implemented the Supreme Court's holding in Trump and present the new indictment to a grand jury that had not heard evidence of immunized conduct. That's neat. So that way they've only heard the non-immunized stuff, so the immunized stuff wouldn't affect their view of how much the non-immunized stuff would work in the case, and see how they do that stuff, actually do their jobs well. Before doing so, the office consulted with Penn for 2 purposes. 1. To obtain Penn's concurrence regarding the proposed election fraud charges under 18 U.S.C. subsections 241 and 371, as required by Justice Manual, subsection 9-85.300, and 2. Given the timing of the superseding indictment, to consult with Penn regarding election year sensitivities, pursuant to Justice Manual, subsection 9-85.500, and the Attorney General's election year sensitivities memorandum. Penn concurred with the return on the superseding indictment, which was returned by the grand jury on August 27, 2024. Following the superseding indictment and consistent with the District Court's instructions, on August 30, 2024, the parties submitted their positions regarding the schedule for pretrial proceedings. The office proposed that I file an opening brief regarding immunity in which it would provide detailed information, without which the court could not undertake the fact-bound analysis that was required by the Supreme Court's remand. The office argued that its filing would include this information that the defense would need to address, and that the District Court would need to make its immunity determination regarding both the allegations and the superseding indictment, and the evidence that the office would introduce at trial, in a manner that would avoid the prospect of multiple interlocutory appeals. Were the defense to file first on remand, it would leave a large gap in the analysis that the District Court was required to undertake, because only the office could identify all the evidence upon which the charges were based, upon which it would rely at trial. The office did not propose a particular date for filing its immunity brief or a schedule for conducting the immunity litigation. It left those matters to the court's discretion. Mr. Trump proposed that the immunity litigation should not begin until December 2024, after the election. The district court issued an order setting a new schedule for pre-trial litigation and directing the office to file its opening immunity brief on September 26, 2024. Prior to filing its immunity brief, the office again confirmed with Penn that the election year sensitivities policy did not apply to conducting such post-indictment litigation according to the court schedule, and that the Justice Manual did not require consultation with Penn regarding such litigation. And after the audience... Jesus Christ. How many pages do I have? 20? Jesus. And after the office filed its immunity brief and Mr. Trump attempted to delay its public disclosure, the district court again rejected his attempt to conflate the election and the criminal justice process. In addition to that, I have 30 In addition to the assertions discussed above, defendant's opposition brief repeatedly accuses the government of bad faith partisan bias. These accusations, for which defendant provides no support, continue a pattern of defense filings focusing on political rhetoric rather than addressing the legal issues at hand. Not only is that focus unresponsive and unhelpful to the court, but is also unbefitting of experienced defense counsel and undermining of the judicial proceedings in this case. Throughout its work, the office was focused entirely on its mandate to uphold the law and nothing more. The career prosecutors and the office conducted its investigation and prosecution in a manner that complied fully with the department's policies regarding election year sensitivities. Fuck. Hold on, page 115. We'll just get into the... You know what? Ooh, this is juicy stuff though. Fuck. I see a lot of numbers. Okay, I think I can skip most of this, so I think I'll get it out of the way. I really want to look at this X stuff. Twitter X. Same fucking thing. Okay. Last section. 5. Investigative challenges and litigation issues. In a corruption or conspiracy investigation, it is not unusual for a subject or target of the investigation to continue to wield significant influence over or command strong loyalty from potential witnesses, often complicating the ability of prosecutors to obtain evidence. That dynamic was amplified in this case given Mr. Trump's political and financial status and the prospect of his future election to the presidency. As described below, one company resisted a lawful court order issued during the office's investigation, and important witnesses made the choice to assert privileges against providing evidence based on their own official positions in the government. In addition, after his indictment, Mr. Trump used his considerable social media presence to make extrajudicial comments, sometimes of a threatening nature, about the case, and office was forced to pursue litigation to preserve the integrity of the proceeding and prevent witness intimidation. Mr. Trump is also able to raise claims of executive privilege and presidential immunity. This section discusses each of those challenges and how the office addressed them. I think I'll only go over the... I don't think I'll go over the executive privilege and presidential immunity. Pre-indictment litigation with third parties. The Twitter X search warrant. Mr. Trump's public statements, and specifically his posts on the social media application Twitter, constitute important potential evidence of his criminal conduct and intent based calling it Twitter. Accordingly, on January 17th, 2023, the office applied for, and the district court authorized a search warrant requiring Twitter to provide certain information regarding Mr. Trump's Twitter account. At the same time, as is common in non-public criminal investigations to prevent individuals under investigations from destroying evidence or otherwise hampering the process, the office asked the district court to issue a non-disclosure order, NDO, which would direct Twitter that it could not inform Mr. Trump that the office was seeking information regarding his account. The district court granted the request and issued the NDO. The search warrant required Twitter's compliance within 10 days of its issuance, but the day before that deadline, its senior director of legal informed the office that, quote, it would not comply with the warrant by the next day, end quote. Shortly thereafter, Twitter's senior director of legal further informed the office that it would not comply with the warrant, quote, without changes to the NDO, end quote, permitting Twitter to notify Mr. Trump of the warrant. Twitter claimed that the NDO impinged on its First Amendment interest in communicating with the former president, which according to Twitter were heightened because the warrant purportedly could implicate issues of executive privilege. They were considered that had no standing to raise any privilege issues. Nice. The district court later described Twitter's actions as, quote, extraordinary, end quote, and noted that its resistance to the NDO appeared to be a first in the company's history. For what appears to be the first time in their nearly 17-year existence as a company, Twitter seeks to vacate or modify an order issued under the Stored Communications Act, commanding that the company not disclose the existence of a search warrant for a user's Twitter account, and further seeks to condition any compliance by the company with that search warrant on the user or user's representatives first being notified about the warrant and given an opportunity to stop or otherwise intervene in execution of the warrant. The office promptly moved in district court to have Twitter show cause why it should not be held in contempt of court, asking the district court to impose a penalty that doubled with each day of noncompliance, starting at $50,000. Oh, you could have started at like $1 million. In rejecting Twitter's basis for refusing to comply with the warrant, the district court emphasized that the search warrant and NDO had been, quote, issued by this court after being apprised of extensive reasons sufficient to establish probable cause for issuance of the warrant and to meet the statutory requirements for an NDO, or for issuance of the warrant, to which reasons Twitter is neither privy nor entitled to be privy, end quote. The district court rejected Twitter's contentions, finding that there existed compelling government interest in maintaining the NDO to preserve the integrity of the investigation, and that as a practical matter, quote, if accepted, Twitter's argument would invite repeal litigation by Twitter and other electronic communication services, provide to challenge NDOs in order to alert users to Stored Communication Act's orders, particularly for high-profile, highly placed users such as current or former government officials, with whom the providers might want to curry favor with concomitant and inevitable delays in execution of Stored Communications Act's orders and result in frustration and expeditiously conducting criminal investigations, end quote. The district court ultimately held that the NDO lawfully prohibited Twitter from notifying Mr. Trump about the warrant and fined Twitter $350,000 for failing to comply with the court-ordered search warrant in a timely fashion, finding that Twitter failed to show good faith and substantial compliance in response to the warrant. The sanction and NDO were both upheld by the D.C. Circuit, and Supreme Court declined to review the case. Upholding NDO with the order was narrowly tailored and, quote, the district court specifically found reason to believe that disclosure of the warrant would jeopardize the criminal investigation, end quote. Holding that the, quote, sanction ultimately imposed was not unreasonable given Twitter's $40 billion valuation and the court's goal of coercing Twitter's compliance, end quote. I don't care about the speech stuff. I've already went over that. Threats and harassment of witnesses. How long is this? Yeah, sure. Okay. A significant challenge that the office faced after Mr. Trump's indictment was his ability and willingness to use his influence and following on social media to target witnesses, courts, and department's employees, which required the office to engage in time-consuming litigation to protect witnesses from threats and harassments. You remember in the Weiss video where he talked about Mr. Joe Biden saying the investigation was politically motivated, or Hunter was basically being targeted for being his son, and how that was so bad. Well, let's see what some actual threats and harassment look like. Let's see what some actual bad stuff looks like. Not to justify Biden's comments, but just saying. Mr. Trump's resort to intimidation and harassment during the investigation was not new, as demonstrated by his actions during the charged conspiracies. A fundamental component of Mr. Trump's conduct underlying the charges in the election case was his pattern of using social media, at the time Twitter, to publicly attack and seek to influence state and federal officials, judges, and election workers who refused to support false claims that the election had been stolen or who otherwise were visited complicity in Mr. Trump's scheme. After Mr. Trump publicly assailed these individuals, threats and harassment from his followers inevitably followed. One witness identified Mr. Trump's tweets about him as the cause of specific and graphic threats about his family, and a public official providing testimony that after Mr. Trump's tweets, he required additional police protection. In the context of the attack on the Capitol on January 6, Mr. Trump acknowledged that his supporters, quote, listened to him like no one else, end quote. Not wrong. The same pattern transpired after Mr. Trump's indictment in the election case, as the D.C. Circuit later found Mr. Trump, quote, repeatedly attacked those involved in the case through threatening public statements as well as messaging daggered at likely witnesses and their testimony, end quote. These attacks had, quote, real-time, real-world consequences, end quote, exposing, quote, those on the receiving end, end quote, to, quote, a torrent of threats and intimidation, end quote, and turning their lives, quote, upside down, end quote. The day after his arraignment, for example, Mr. Trump posted on the social media application Truth Social, quote, if you go after me, I'm coming after you, exclamation point, end quote. The next day, quote, one of his supporters called the district court judge's chambers and said, quote, hey, you stupid slave, harder, fuck? If Trump doesn't get elected in 2024, we are coming to kill you, so tread lightly, bitch. Fuck, I think. You will be targeted personally, publicly, your family, all of it, end quote. Wow. Sanest Trump supporter. Mr. Trump also, quote, took aim at potential witnesses named in the indictment, end quote, and, quote, lashed out at government officials closely involved in the criminal proceeding, end quote, as well as members of their family. You stupid slave harder bitch. Or fuck. To protect the integrity of the proceedings on September 5th, 2023, the office filed a motion seeking an order pursuant to the district court's rules restricting certain out-of-court statements by either party. The district court heard argument and granted the office's motion, finding that Mr. Trump's public attacks, quote, pose a significant and immediate risk that 1. Witnesses will be intimidated or otherwise unduly influenced by the prospect of being themselves targeted for harassment or threats, and 2. Attorneys, public servants, and other court staff would themselves become targets for threats and harassment, end quote. Because no alternative means could adequately address these grave threats to the integrity of these proceedings, the court prohibited the parties and their counsel from making public statements that, quote, target 1. The special counsel prosecuting this case or his staff, 2. Defense counsel or their staff, 3. Any of this court's staff or other supporting personnel, or 4. Any reasonably foreseeable witness or the substance of their testimony, end quote. The court emphasized, however, that Mr. Trump remained free to make, quote, statements criticizing the government generally, including the current administration or the DOJ, statements asserting that he is innocent of the guilty of the charges against him, or that his prosecution is politically motivated, or statements criticizing the campaign platforms or policy of his current political rivals, end quote. Wow. If only conservatives could read. A gag order. Mr. Trump appealed, and the D.C. Circuit affirmed, in large part, finding that Mr. Trump's attacks on witnesses in this case pose, quote, a significant and imminent threat to individuals, end quote. Oh, no, not end quote. Willingness to participate fully and candidly in the process to the content of the testimony and evidence and to the trial's essential truth-finding function, end quote. With, quote, the undertow generated by such statements, end quote, likely to, quote, influence other witnesses, end quote, and deter those, quote, not yet publicly identified, end quote, out of, quote, fear that if they come forward they may well be the next target, end quote. Likewise, quote, certain speech about counsel and staff working on the case poses a significant and imminent risk of impeding the adjudication of the case, end quote, since, quote, messages designed to generate alarm and dread and to trigger extraordinary safety precautions would necessarily hinder the trial process and slow the administration of justice, end quote. The Court of Appeals explained that the district court's order, quote, involved the confluence of two paramount constitutional interests, the freedom of speech guaranteed by the First Amendment, and the federal court's vital Article 3 duty to ensure the fair and orderly administration of justice in criminal cases, end quote. Balancing these interests, the court explained, required consideration of three related questions. Well, now we're getting into it. Come on. Oh, okay. Well, that was all that stuff. Executive privilege, don't care, we went over that. Immunity, we went over that. I think that's it. Conclusion. Nice and short. On remand from the Supreme Court's decision in Trump, the district court set a litigation schedule whereby the parties would submit briefs regarding whether any material in the superseding indictment was subject to presidential immunity. The parties were in the middle of that process when the results of the presidential election made clear that Mr. Trump would be inaugurated as President of the United States on January 20th, 2025. As described above, it has been the Department's interpretation that the Constitution forbids the federal indictment and prosecution of a sitting president, but the election results raised for the first time the question of the lawful course when a private citizen who has already been indicted is then elected president. The Department determined that the case must be dismissed without prejudice before Mr. Trump takes office. The office therefore moved to dismiss the indictment on November 25th, 2024. The district court granted the motion the same day. The Department's view that the Constitution prohibits the continued indictment and prosecution of a president is categorical and does not turn on the gravity of the crimes charged, the strength of the government's proof, or the merits of the prosecution, which the office stands fully behind. Indeed, before Mr. Trump's election and imminent return to the presidency, the office assessed that the admissible evidence was sufficient to obtain and sustain a conviction at trial. And then you got a timeline of everything. And then this, I believe, this is the asking them to not release the draft report, which we just read. So they're basically asking, hey, don't do that. And this is Jack Smith saying that he has, I think he's just saying he used the classified documents section of my report, which he would not be releasing until the prosecutions against Joaquin Nada and Carlos de Oliveira are done, so as not to affect the trials. So, damn, it's, they did everything, they did it right, they had so much fucking evidence. He would have been dead to rights if that had went through, but because of their sticking to the policies and their interpretation of the Constitution, of not charging presidents, they are not continuing. And even if they did, as soon as Trump came into office, he would have dismissed Jack Smith, stopped the investigation. So, what was it all for? I guess people like me to read it, understand it, and try to show to you what really happened, and that this man will become our president. So, I guess, hey, finally, go watch my J6 videos. I'd like if you watched all my videos, including the ones on the classified documents, but if anything, watch my January 6 videos. And if you're going to watch any of them, watch the parts going over Destiny's notes and the timeline of what actually happened on January 6th. The indictment, it's good, but going through the actual timeline of January 6th, that is what I can't recommend enough. Please. Or, if you just want to read Destiny's notes and the full timeline itself, you can go to, I think it's destiny.obsidian, I think. Or you can just look up Destiny Obsidian Notes, and then you should be able to go to it. It's on Obsidian's a note-taking app, and then it will be under, what was it under? Jesus. It was under one of the things, because there's multiple tabs that you can click on. You click on one of them, and then it should be like right there, like J6 or January 6th, something like that, if you just want to read the notes for yourselves. But, if you want to read my reading of them, my little insights, that's also nice. But if you're going to do anything, if you want to learn anything else about it, either look at those notes or look at my video going over those notes. And then if you also want to go over the J6 indictment or the classified documents indictment, any of that stuff, do that as well. If you're even the slightest bit interested or want to know more, please do that. But it is 9:25, and I have been doing this for like 3 hours, 3.5 hours. My throat, my mouth is so dry, it hurts. Okay, so I'm gonna go off here. So I guess see you another time. So bye.